Chairman Gensler, recently a federal court called your rejection of a Bitcoin ETF, quote, arbitrary and capricious. In a subsequent interview, you dismissed the judge's opinion. Asked a follow-up question, if anything a judge says would change your mind, you responded, quote, well, no, not really. It seems that you don't really recognize the authority of the judicial branch. You seem to have a love for the Howey test, selectively applied as illustrated by Mr. Torres. But, in light of those reactions, what should people make about the Bitcoin ETF? How will the SEC revise its approach?
We have great respect for the courts. I personally have great respect for the courts. We're considering that. It's still an active consideration at the commission. And
so you haven't made up your mind? I got to tell you.
Familiar with the case.
Yeah, I got to tell you that many market participants have reached out and are concerned that you will arbitrarily, perhaps also capriciously, pull recent filings ahead of others who've been working with the SEC for years to get an approval for a Bitcoin spot ETF. Will this resemble some sort of free pass for one favored company while others remain locked out? And I ask that because it seems that's happened before at the SEC.
Sir, I'm not sure if I'm following. I mean, we're still considering that court case and the application, as you say, to Bitcoin exchange-traded products.
Are you going to preserve people's place in line, or are you going to pull ahead a favored transaction or another on the consideration of a Bitcoin spot ETF? Are you going to preserve the place in the queue? Because timing matters. People have worked on this for years, and then you get a recent filing by somebody big in the market, and it seems like, oh, yeah, let me take your calls. How can I help? Meanwhile, you've given the stiff arm, as I've said, Hotel California-style regulations where you can check in with the SEC, but you can never leave with clarity. And how about the legislative branch? Do you recognize the authority of Congress or the laws that we pass?
Yes, we comply with the laws that Congress passes every day.
Well, I've heard you say that about the courts and now Congress, which is encouraging, but I am inclined to judge your deeds more than your words. And, I'll pick up where one of my colleagues, Mr. Huizinga, left off with the Supreme Court decision in West Virginia versus the EPA. Are you familiar with that case?
Yes, sir, I'm familiar. It's an important case.
Glad to hear you say that. And it would be binding, correct?
It's the law of the land, sir.
That's right. And it introduces a major questions doctrine. And you told Mr. Barr that you received tons of feedback on your proposed ESG disclosure rules, feedback that should make clear that the proposal for ESG disclosure is a major question. And it should make clear that you don't have the legal authority to do that. So I'd ask you to knock it off. Cease and desist and work with this body to pass a law if you want to regulate something. Frankly, your time as chairman has highlighted two problems, a Gary Gensler problem and a structural flaw in the SEC. And as I told you in April, I've proposed a solution called the SEC Stabilization Act. You're making the case for this bill easier every day you are acting as the chairman by doing rulemaking after rulemaking without any regard to the impact of these rules, or maybe that's the feature for you, I don't know. But it's having a massive impact on our markets. I mean, we have markets that truly are the envy of the world, and why would you disrupt them, with processes that are driving capital out of our markets? Not because to avoid our laws, but to find some place where they can get clarity, where they can work with a regulator and get a decision and a path forward. So instead of selectively applied, you are you're not providing clarity with a rule that's evenly applied. You're intentionally shortened comment periods to limit feedback. And the courts have even called this arbitrary and capricious. You're pushing a woke political and social agenda, and I think abusing your role and the authority of the SEC as cover. So, I think fundamentally, the SEC Stabilization Act would remove the role of chairman. It would preserve the current commissioners, but it would add a sixth commissioner. So there would be no more than 3 from any one political party. And so that would provide a path that would make the SEC do what you're avoiding. Frankly, you're front-running Congress, you're front-running the courts, you're front-running even the own administration, and no one has held you to account for that. I mean, I wish the Biden administration would say you're fired. but the list of folks they need to do that for is long. Congress hopefully will with the SEC Stabilization Act. I yield.
I'd like to shift gears to digital assets. In July, I was proud this committee passed comprehensive digital asset legislation, bipartisan, including my amendment directing the SEC and CFTC to do a joint rulemaking, creating a process for delisting an asset. Since 2019, I've said that clear rules of the road for digital asset firms are critical to protect consumers and promote innovation here in the United States. You've claimed that you have all the authority you need, I know before us, but a rulemaking process hasn't started yet. Can you explain to us why, please?
Well, because there's already laws and rules in the books. There's rules and laws in the book that apply to crypto security tokens like they apply to others. And there's nothing incompatible because you're storing something of value on a blockchain ledger. We talked earlier about being technology neutral. Whether you're storing that at DTCC, the public clearinghouse, or you're storing it on an accounting ledger called blockchain, it's still a transfer of value, and the public is maybe, depending on the token, anticipating a profit based on the efforts of others. As it relates to the crypto, so-called crypto exchanges, they're doing what we wouldn't even allow anywhere else. They're commingling, co-bundling, trading against the public, and sometimes front-running the public on their platforms.
So memorandums of understanding have long been used and adopted in a number of contexts. In June 2022, you told the Financial Times you were working on an MOU with the CFTC to avoid regulatory gaps for crypto. Can you give us an update on the status of the MOU, please?
I was hopeful that we would do something there, but what we do is on a case-by-case basis and issue-by-issue basis work with the Commodity Futures Trading Commission with regard to this crypto field. They have important authorities. They execute against those authorities. We do against our authorities, really both with the same goal of protecting the public.
Thank you, May. Have a sweet new year. Thank you.
Chair Gensler, last time we were here, I asked you about Ether. In 2018, you say that Bitcoin, Ether, Litecoin, and Bitcoin Cash are not securities. So I want to focus today on Bitcoin. Why do you believe Bitcoin is not a security?
Thank you, Chair. And I think you're referencing remarks I made as a professor at MIT. And as I wrote in that paper at that time, it was really about something called the Howey test. And the Supreme Court, it's the law of the land, talks about if the public is anticipating a profit based on the efforts of others. And as I think I noted in that paper back in 2018, I didn't see that Bitcoin
But your view on Bitcoin, you've made comments on this. You believe Bitcoin is not a security. Is that true?
Well, I think the staff of the SEC have also, and the prior chair.
I'm just asking you this question, and this is not a gotcha. I thought this was going to be an easy softball into harder questions. Do you think Bitcoin is a security?
No, I think I've said this in the past that I think that it doesn't
I'm asking you
meet the
to
Howey
answer
test.
my question now. This is not supposed to be hard.
I know. I said it does not meet the Howey test, which is the law of the land about being an investment
So it doesn't meet the
contract
Howey
or security.
test. So therefore, it's a commodity. Is that fair?
I would say it's not a security, and then the test is otherwise for other laws.
Well, the CFTC says they don't have the authority over Bitcoin and digital commodities. Do you think legislation is necessary to protect consumers in the world of digital assets, in particular, given that gap around just Bitcoin?
I think, as I've testified here in this committee room 4 years ago as a private citizen, that for the parts of the crypto ecosystem that are not securities, though under the Commodities Exchange Act, the CFTC has some anti-fraud authorities, they don't have what's called plenary authority to write rules around that. And as I've said in the past, I've been supportive of our sister agency, if I can say that, an agency that I once was honored to chair and I like quite a bit, doesn't have that plenary authority, and if Congress moved forward on that, that could help them.
So the spot market lacks a regulatory paradigm and established law. So should we take action there?
I'm sorry, I'm not sure I follow. The U.S. stock market you're talking about, the securities
No,
market?
the CFTC. I'm continuing with your answer. My follow-up there was because there's not a regulatory remit that Congress has given them, clear regulatory remit, we should step in. So let me just move on. I've talked about your non-compliance with document requests made by this committee. You believe the commission must vote in order to produce non-public information to this committee. Do you not?
Under the Exchange Act, I do believe that the commission needs that vote.
Have you scheduled a vote necessary to provide the non-public documents to this committee?
We, I think, have been working with your staff and believe in oversight of this committee, we've provided somewhere over 40,000 pages
Yes,
of
nothing,
documents.
as I said in my opening statement, nothing that was non-public did you provide. In fact, you produced one of the letters that we wrote to you as responsive documents. It showed the absurdity of it. So the General Counsel's Office has indicated to my staff that after a 10-week review process, these documents are ready to be transmitted. It just needs a vote. When do you intend to schedule that vote?
We continue to work with you and your staff. We've had, the commission has approved that some senior staff will be taking transcribed interviews, I think, with your staff. And
But that is not responsive to my document requests. This should not be the hard work of a chairman to answer these questions. You have 30 major rulemakings, but you won't even provide basic documents to us. Your unresponsiveness is non-compliance, and we'll have to take action if you're not willing to comply. You have a 10-week review process, and you've not provided documents. Furthermore, you haven't even done the economic analysis of your interplay of these major rulemakings that are going to affect anybody who owns a stock, bond, or any type of security. And so you've got serious questions to answer to the public and to Congress, and we intend to get your compliance. We can do it the easy way or the hard way. And with that, I yield back.
Chair Gensler, regarding cryptocurrencies and shifting gears, I'm interested in why you have pursued a litigation-heavy strategy, despite the fact that neither you nor any of your senior staff are litigators, neither your chief of staff nor your policy director or even your general counsel. Why have you settled on such a litigation-heavy strategy to address the cryptocurrency market?
Frankly, it's because the field is so rife with hucksters and fraudsters and non-compliant parties, but we've also done rulemaking, one related to broker-dealers that was completed a number of years ago, and then others related to the definition of exchange and the custody rule that's been discussed a bit here, and even something called best execution. But this is a field where the American public's at risk and being harmed every day on these platforms that are commingling and trading, often trading against their customers.
Well, in my view, it seems that these cases are brought with an explicit political agenda, not a substantive legal one.
Nothing could be further from the truth. There's nothing, the only thing political is protecting the American public, which I think members on both sides of the aisle probably agree. They don't want to see constituents hurt in a place where a lot of crypto projects are not properly disclosing. There's been all too many bankruptcies, and in the bankruptcies, investors are just lining up at the bankruptcy court.
Well, thank you. In my opinion, I'd like to see you do more from the regulatory and guidance side because this industry is so important and we need to foster it, in my view. Thank you, and I yield back.
Thank you, Mr. Chairman. Chair Gensler, I'd like to continue our discussion about SOB 121 staff bulletin from the SEC that would potentially have significant effects on the ability of banks to custody digital assets. Let's briefly begin by following up on something that was raised the last time you were in front of this committee. You previously said that prior to the issuance of SOB 121, your staff did not confer with any of the prudential regulators. Is that correct?
You'd have the transcript, but I think that our staffs do talk to the prudential
prior to the
regulators.
issuance of SOB 121, did your staff confer with any of the prudential regulators?
Oh, with regard to that particular
Correct.
staff bulletin, I don't recall that they did. I know that they have
So let's let the record reflect that the SEC staff did not think to confer with the prudential regulators before issuing the staff accounting bulletin. In response to my question for the record from April on this topic, you stated, quote, SOB 121 provides non-binding staff guidance on the application of existing accounting and disclosure requirements under U.S. GAAP. Prior to the issuance of SOB 121, Mr. Chair, did FOSB issue anything related to the custody of digital assets, and if so, what was issued?
I'd have to get back to you, but if you're asking about the Financial Accounting Standards Board, I don't know that they had done something on custody, but we could get back to you.
Since you cited the generally accepted accounting principles in your response, I decided I'd take a look at this myself. Prior to SOB 121's issuance, FOSB had not published anything related to the custody of digital assets. In fact, the board added accounting standards for digital assets to its agenda in May of 2022, 2 months after the issuance of SOB 121. Your response to my question, for the record, from April, also indicated that SOB 121 provides guidance on the application of existing accounting and disclosure requirements under the SEC rules. So here's a question. Prior to the issuance of SOB 121, what rules had the SEC finalized relating to the safeguarding of digital assets?
Well, we have on the books a rule from 2009 that applies to the custody of digital assets by investment advisors because it covers all funds and securities. That rule's on the books. We also had finalized something around special purpose broker-dealers, which relates to crypto broker-dealers.
So I took a look at this topic myself. The answer, quite frankly, is none. There were no SEC rules on the books that directly address the topic of custody of digital assets. As you know well, the SEC issued a proposed rulemaking on custody, including digital asset custody, in February of 2023, and that rule has not been finalized to this day. So to recap, the SEC failed to confer with prudential regulators despite the fact that anything changing rules around the custody of assets for banks, regardless of whether the bank is publicly traded, would be of obvious consequence to them. Then, when justifying the bulletin, the SEC cited the GAAP and SEC rulings. However, at the time when the bulletin was issued, there was no action by FOSB, no rulemaking from the SEC on this topic. In April, you said you wanted the SEC to, quote, stay in our lane, end quote, with regard to SOB 121's potential effects on a bank's balance sheet. It's fair to say that the fact pattern we have is that the SEC is not just going out of its lane, but it failed to comprehend the existence of any conflict with prudential rules. Additionally, the SEC's justification for issuing the bulletin is based on accounting guidelines that did not exist when the bulletin was issued and rulemaking that was not even started until nearly a year after the bulletin was issued. It's pretty obvious that one of two things happened, and both are bad. On one hand, it's possible that the SEC was well aware that there was no strong justification for issuing the bulletin and chose to do it anyway. That would show a pretty straightforward case of regulating by guidance and unsubstantiated theory. On the other hand, the SEC made some obvious basic mistakes in the issuance of this bulletin. In light of these mistakes, it's worth mentioning the SEC Inspector General's report on management and performance challenges. Among other things, the report indicated that very high attrition has required the SEC to rely on detailees with little or no experience to contribute to the core regulatory tasks such as rulemaking. The case of SOB 121 raises the question of whether the SEC is compromised. Thank you, Mr. Chairman. I yield back.
I want to move on to our grayscale letter. I sent a letter to you yesterday along with my colleagues, Congressman Flood, Torres, and Emmer, urging you to approve the listing of spot Bitcoin ETPs after your recent loss in court to Grayscale. Now that the SEC has the court's decision in hand, rejecting your rationale for denial, does the SEC plan to approve the current pending spot Bitcoin ETF applications?
Thank you for your letter. I did read it last night. Again, we're still taking this under advisement. It's a recent court action, and staff and commissioners will take it up as appropriate.
The court concluded that the SEC's denial of grayscale lacked, quote, a coherent explanation and then, quote unquote, falls short of the standard for reasoned decision-making, and then was, quote unquote, arbitrary and capricious. How do you explain the SEC's actions there?
We do that which we do under the law as best we can. Sometimes things go into court. We're still considering that court decision. I think it was a district court. I'm sorry, it was appellate court. It was appellate court, but we're still considering that appellate court decision. I don't want to get ahead of the staff or my fellow commissioners.
Last time you were before the committee, I voiced my concerns regarding your reckless approach to rulemaking, lack of capital formation agenda, crusade against the digital asset ecosystem, and unresponsiveness to Congress. So many things change, so many things remain the same. Those are the same issues on the docket today. This means that in the last 5 months, you've done nothing to remedy the legitimate and often bipartisan concern expressed by this committee and these committee members. That is disgraceful. So let's run through them again. Let me be clear, Chairman Gensler, our patience is wearing thin. First, the Securities and Exchange Commission's current approach to rulemaking jeopardizes the integrity of our financial markets and puts investors at risk. There's a critical need for comprehensive economic analysis of the rules you've proposed and their interaction with one another. Under your leadership, the Commission has failed to adequately assess their interplay and cumulative impact. That's shoddy work for an important agency and does not adhere to the SEC's mandatory statutory authority. While the Securities and Exchange Commission is engaged in a wide-ranging regulatory agenda, you seem to have overlooked the importance of public input, resulting in bipartisan bicameral concerns. Members of both sides of the aisle have raised valid concerns regarding the MiFID relief, swing pricing, hard close, as well as your equity market structure overhaul. The Securities and Exchange Commission has taken no action to address these concerns. Second, you continue to fail to prioritize capital formation. Among your expansive rulemaking agenda items, there is not a single initiative aimed at improving access to capital or enhancing market competitiveness. Third, your efforts to choke off the digital asset ecosystem, which has created real harm for consumers and our markets, is clear to all. You said the law is clear, but your actions have created more confusion and lasting damage. Chair Gensler, you've also said your goal is consumer protection. Yet your actions have pushed legitimate digital asset activities outside of regulated financial institutions where consumers are best protected. On one hand, we've seen bipartisan votes in Congress, in this committee, to provide clear rules of the road and real consumer protection. And on the other, we've seen your ad hoc regulation by enforcement approach to digital assets on a losing streak in the courts. You refuse to be transparent with Congress regarding your interactions with FTX and Sam Bankman-Fried. That's the investigation we started last Congress. Finally, your lack of responsiveness to this committee's legitimate oversight continues to be unacceptable. And I want to finish here. In February, the committee made multiple requests for documents to the Securities and Exchange Commission. This is normal congressional oversight. Yet 7 months later, the committee has not received a single non-public document that was not part of a FOIA production. As I said, our patience is wearing thin. The SEC is not above the law, nor is it unique. Other financial regulators have routinely complied with congressional oversight. So let me be clear. I do not want to be the first chairman of this committee to issue a subpoena to the Securities and Exchange Commission. And you should not want to be the first SEC chair to receive a congressional subpoena. Either we find a path forward where the SEC recognizes Congress as a co-equal branch of government and is responsive to our oversight duties, or my option is to issue a subpoena. It's time for you to consider the lasting consequences of your actions, and what that means to the Securities and Exchange Commission's reputation long term. While your time in this role may be temporary, the repercussions for your actions may be permanent for the agency. I yield back.